Jeff Greenbaum. I am the head of public policy at the International Advertising Association. And I want to welcome you to our first of 3 webinars that we're holding this year on issues related to environmental marketing around the world. This webinar is produced in cooperation with lawyers from the Global Advertising Lawyers Alliance, who are experts in advertising law around the world. And maybe we can actually have them pop up on the screen, and I will introduce who our panel members are today. Today, like I said, is the first of our 3 webinars. This week is going to be focused on Europe, and then during the course of the year, we're going to focus on other areas around the world. The reason we're doing environmental marketing is, sustainability is certainly a huge focus of companies and consumers and regulators, and we are seeing both in Europe and around the world increasing attention on these issues from all fronts. So as you can see on screen, you've got Jonas Gassman from Switzerland, Hande Hançar from Turkey, Daniël Haije from the Netherlands, and Brinsley Dresden from the UK. And what we're going to do in the next hour is take you on a whirlwind tour of some things that are going on around in Europe. So what I'm going to do is we're going to put the presentation up on the screen. There you see, there's the folks. And what we're going to do is we're going to jump right in and first start with the framework. For those of you watching in the US, you know that there are state laws governing environmental advertising around the United States, as well as the green guides and from the Federal Trade Commission, but things are very different when we're talking about the EU. So let's kick it off with Daniel.
Yeah, thanks, Jeff. And hi, everybody. Really nice to be here in my office, but yeah, speaking to you guys. So in the Netherlands, there is actually no specific statutory rules on environmental advertising. Everything is generally regulated by the Unfair Commercial Practices legislation from the Unfair Commercial Practices Directive, the EU directive. But there's actually some guidance on how to interpret the statutory rules, and some important guidance was handed down by our supervisory authority, the ACM, guidance on sustainability claims. They contain basically 5 rules of thumb on environmental claims. You make clear what sustainability benefit the product offers. You substantiate your sustainability claims with facts and keep them up to date. Yeah, comparisons with other products, services, or companies must be fair. You must be honest and specific about your company's efforts with regard to sustainability. And you have to make sure that visual claims and labels are useful to consumers and not confusing. So those are the 5 rules of thumb, and that's an excellent, I think, summary of what's going on in the Netherlands on that. We also have a self-regulatory rules in the Netherlands, a self-regulatory system, which functions very well, and we have a specific code. So there are specific self-regulatory rules on sustainability claims, and they're in the code for sustainability advertising. More on that later, I guess. There is guidance on self-regulatory rules as well, and that's the case law of the Advertising Code Committee. That's basically it in the Netherlands.
All right, thanks, Daniel. Jonas?
Yes, thanks a lot. Pleasure to be here. In Switzerland, there's no specific statutory rules on that environmental marketing. But in general, we can say that the legal advertising framework is spread really through a number of different statutes. And we also do have sector-specific regulations, such as on drugs or on alcohol. And what is of pretty great importance is the general rule of the prohibition of misleading or deceptive advertising. And this one is enshrined of course, in the general Swiss Federal Unfair Competition Act, but also, for example, in the Swiss Federal Foodstuffs Act, which not only applies to foodstuff, but also to utility articles. And it is worth noting that both the infringements of these provisions are subject to criminal prosecution. And we also do have self-regulation. We have the Swiss Commission for Fairness in Commercial Communication, the regulatory body. They do not have any judicial power, but they can still make recommendations or publish a judgment they made. And they also do, as you might be aware, they do take into consideration the ICC codes, the codes of the International Chamber of Commerce on advertising. So yeah, that's really a short wrap up on the regulatory situation in Switzerland.
Okay, thanks. Hande, Turkey.
Thank you. Hi, everyone. Thank you for joining us today. So in Turkey, we have a specific article under the Regulation on Commercial Advertisement and Unfair Commercial Practices, which rules the environmental marketing claims. But the article, in fact, sets very basic rules and only states that the environmental claims should not abuse consumers' environmental awareness or the lack of knowledge, and the signs, symbols used related to environmental claims must not be misleading. So these rules are not very comprehensive. But on December 13th, 2022, the Advertising Board published the guideline on environmental marketing claims, and this guideline contains very detailed rules and examples which are all very instructive. So today, during the webinar, I will be talking mostly about this guideline, as the Advertising Board started to strictly apply this new guideline. I think that's all for Turkey as a legal framework. Thank you.
All right, thanks, Hande. And finally, in our first topic, Brinsley. So, a client said to me recently, what is going on in the UK? There's a lot going on in the UK.
Oh, there's a huge amount going on in the UK, and it's bonkers. Some good news just announced yesterday was that I'm trying to think of a polite way of saying this ill thought through proposal for us to shred all of our European-derived laws post-Brexit, that has now been shelved. So Daniel mentioned the Unfair Commercial Practices Directive that they have in the Netherlands. We have the UK version of that we implemented it too. Statutory rules come from the Unfair Commercial Practice Act, which is all about misleading advertising. This is all regulated then, again, similar to the Netherlands. You've got the Competition and Markets Authority, which for our American viewers is equivalent to the FTC. They are very focused on this area now. They have been for a couple of years, having previously not taken much interest. Previously, it was all down to the Advertising Standards Authority, our self-regulatory body, which is similar to the NAD. The problem is that the ASA doesn't have jurisdiction over packaging claims. So the CMA had to step in to fill that gap and deal with non-advertising, strictly speaking, claims like packaging claims. So the ASA have their codes and the CMA has a green claims code. They're very, very similar. They're basically covering the same ground, but for different media. But there's a lot of underlying guidance which is coming out all the time, particularly the ASA is constantly producing new decisions and also new guidelines which you have to follow. And just to say, Jonas mentioned the ICC codes. They do apply in the UK, but to be honest, we don't tend to look at them very often because we don't really need to, because everything is really laid down by the ASA in their codes and in their guidance. So they're consistent with the ICC codes, and therefore we don't tend to look at the ICC codes very much. And that's it for the UK.
Okay, great. Thanks, Brinsley. All right, so the next topic we're going to talk about is you're making an environmental marketing claim. What kind of proof do you need to back up that claim? What kind of substantiation is required? You know, in the United States, we would probably just say typically you need competent and reliable scientific evidence to back up your claims. But a lot of really interesting questions get raised when you're starting to talk about environmental marketing, of course, because you start to think about life cycle analysis and other types of things you have to take into account that may be broader than the claim itself. So let's go back and kick things off with Daniel.
Yeah, thanks. So again, in the Netherlands, there are no specific statutory rules on substantiation of environmental claims. There is a general unfair commercial practices rules, and they include a reversal of the burden of proof, mainly stating, as an advertiser, you should be able to prove your claims, and generally there is a robust proof is required. There is also that ACM guidance that I mentioned, so which states that sustainability claims must be substantiated with facts and kept up to date. Very important. But there's some important upcoming legislation now in the EU, the proposal for a Green Claims Directive. I'm sure we'll talk about that later on. But most notably, for making green claims, environmental claims, explicit environmental claims, you have to rely on widely recognized scientific evidence. The proposal was supposed to include a common or a universal method of, or a prescribed method for substantiating green claims, but that has been left out. So, and most notably, member states will need to adopt verification procedures regarding green claims for compliance with the rules. And green claims will have to be verified before actually using them. So that's a very notable development in EU law. If this,
but we don't really know what that means. I mean, there's not enough guidance to point in the directive to know.
No, and I mean, it is still a proposal. It still has to be adopted by the European Parliament, and so there are a lot of amendments expected, and this will be a point of discussion, I'm sure. So then, apart from statutory rules, there's the self-regulation, and that's definitely, there are strict substantiation requirements in the Code for Sustainability Advertising. I will talk a bit to that later on. Thanks.
All right, Jonas.
Thanks. Yes, there are no specific statutory rules in Switzerland on this topic as well. But of course, any statement of fact which is included in such claim must be substantiated by sound evidence. And whether or not a claim includes such a statement of fact is depending on the perspective of the average consumer. And the Swiss Federal Supreme Court made a pretty interesting and pretty firm statement that goes back to 2013. It said that in the context of furniture, the Swiss average consumer can be considered informed, critical, knowledgeable, and price sensitive. So a pretty firm statement and a good statement, I would say. And with that in mind, it is possible to judge whether there is a fact element in the claim, and then based on that, you have to either substantiate it or not. And more specifically on the claim of product being recyclable, we come back to that later on in the discussion, and I will elaborate on that a bit more. Thanks.
Makes sense. Okay, Hande. Hande, you're on mute.
Sorry, I forgot to unmute myself. So the guideline sets very high standards for the substantiation of the environmental marketing claims. Any claim must be substantiated by concrete facts, scientific studies, or such claims must be based on the findings of the recognized academic institutions. In addition, the methods used for measuring the environmental impact must also be clearly identified and communicated to consumers. There are also very detailed rules about the recyclability or the renewable energy, but we will discuss them later. So can you please pass to the next slide? So yeah, according to the guidelines, the claims must clearly identify to which product, to which parts of the product, or to which part of the process, the manufacturing process of the company they are related to. It must be very specific. For instance, if there is a comparison, the compared facts must be very clear. Here, the guideline gives an example. For instance, if you use 20% more recycled component, this is a misleading statement according to the guideline, because it is not. It is hard to understand if the comparison is made between the advertiser's own products, new and old products, or between the advertiser's product and the competitor's product. So this is not clear, and the board would not accept such a statement alone. it must be accompanied by further explanatory notes. Also, another important and final note is that if the advertising medium is not suitable to communicate all the information to the consumers, then the consumers must be expressly and clearly directed to a website or another source where they will find all necessary information to understand the substantiation of these claims. So the standards are very high, and I can say that the board is very keen to apply these high standards for the burden of proof. Thank you.
Thanks, Hande. Okay, and Brinsley.
Yes. So look, I mean, probably the key thing is you've got to have robust substantiation for environmental claims, but in particular, the ASA has developed this requirement for substantiation based on the full life cycle of the product, and that has tripped up many advertisers. For example, Alpro had claims for their almond milk product, but they didn't have it on the full life cycle of the product. We're going to look at another example in a video in a few minutes that's coming up. It's also can be a problem if you have substantiation that omits significant information about the environmental impact of a product. So generally, the substantiation, again, is required to a high standard. And I think in common with my colleagues in these other countries, there is an obsession about greenwashing. And as soon as you make an environmental claim, various kind of campaigning groups and various regulators are likely almost to sort of assume that you are greenwashing. As I think Daniel mentioned, the burden of proof is on the advertiser, not on the regulator or the complainant. So the advertiser must be able to prove that their claims are not misleading. That implies you have the substantiation, and you have to have it in advance at the time that you publish the claim. You can't put it together later on if and when you have a challenge. It's probably enough for the UK.
Okay. Our next. Oh.
This is the example. That was the Alpro example, which basically fell down. High level claim, good for the planet. I think the ASA generally accepts that plant-based products have a low environmental impact than things like dairy products. But what Alpro didn't have was a full life cycle analysis on their specific product, and therefore good for the planet was held to be misleading, and the complaints are upheld.
So this is a great transition to our next topic, which is, what do you do about general environmental benefit claims? If you want to claim that your product is green or good for the planet or environmentally friendly, does that pose a problem? In the US, the FTC says general environmental benefit claims are a problem, and that advertisers should make specific claims, not claim broad benefits, because, like the ASA said, it can communicate other potential benefits. So let's see what the views are around Europe. I guess we're starting with Daniel.
Yeah. So our authority, consumer authority in the Netherlands, also thinks that generic claims are a problem. They're vague. Consumer will not easily understand what is actually meant with the claim. So the guidance our authority gives is general environmental claims without detailing a specific environmental benefit are deceptive. That's the view of our authority. Now there's also a new EC European proposal for EU directive amending the Unfair Commercial Practices Directive, which contains a ban on making generic environmental claims. I should say where the excellent environmental performance of the product or service cannot be demonstrated. So you could make a generic environmental claim under this proposal, but you would need to be able to show the excellent performance in environmental perspective. So yeah, that's for the Netherlands.
Jonas?
Yes, thanks. I can pretty much second that, and also what Jeff said before. So yeah, generally they should be specific and eligible for substantiation. And by way of example, we came across the claim as suggested by one of our clients, ethically sourced and made. And we there took the stance and advised that this would most likely be considered by a Swiss court as too broad, because it is not really clear to what it really relates. So we advise the client to make it more specific, and they indeed wanted to refer to the labor conditions, and they also held a certification in that respect, and so that was not really an issue in the end. And it is also worth noting that advertising self-evident facts is unlawful under Swiss law. So if you take properties of a product that are required by law, you cannot advertise them as in a claim. And also it again comes all down to the perspective of the average consumer on the one I elaborated before. And this one is really decisive in advertising in general. Yes. Thanks.
All right. Thanks, Jonas. Okay, Hande.
So, I mean, the general environmental benefit claims are not accepted in Turkey either. So any claim must be accompanied by detailed explanations to substantiate the claim, and the burden of proof is quite high. So if one cannot understand from the advertisement what aspect of a product or service claimed to be green is green, then the advertisement will be deceptive. So there should be no ambiguity on the part of the consumer according to the guideline. Next slide, please. So, for instance, in this decision regarding Martı, Martı is a very popular rental scooter brand in Turkey. The board found this statement that Martı has saved carbon dioxide emission equal to 250,000 trees, etc., as a misleading statement because the company couldn't substantiate this claim with a verifiable strategic plan. So according to the board, these kind of claims which are not substantiated are general marketing claims and deceptive. So next slide, please. In this decision, which is regarding Vodafone, a telecommunication company, and here the company used the statement, Turkey's one and only service provider that uses 100% renewable energy. So this is also a general statement because the company couldn't substantiate this claim. But here there is also another point that is taken into account by the board, because here the company creates an unfair superiority because it creates the impression that they are one and only. But the board investigated this claim and found out that there are also other telecommunication companies which generate their electricity consumption through renewable energy. So this decision is, in one hand, is a deceptive, a general marketing claim, but on the other hand, it also creates an unfair superiority against the competitors. So yeah, the general claims are not accepted in Turkey as well.
Thanks. And to the UK.
Yeah, so they can be misleading. The more general it is, the more difficult it will be. And I think we've got a couple of little videos now, a couple of TV commercials. So if we could look at the first one, please. So this is for Tesco, if it works.
Ooh, and that's not what Zoe likes to hear. But she's going to roll up her sleeves and do her bit. Told you. And there it is. A delicious Tesco Plant Chef burger. We've lowered the price of dozens of our Plant Chef products because a little swap can make a difference to the planet. Tesco. Every little helps.
So the problem with that one is that it's linked to a specific product, a plant-based burger, and Tesco were asked to provide their life cycle, their full life cycle substantiation that this would have an environmental benefit because it was a soya-based burger rather than a meat burger. And although the ASA was willing to accept that in principle, they said, we still need to see the full life cycle analysis for this particular product. Tesco didn't have it, and so the complaint was upheld. Now, on the same day last June that complaint was upheld, the ASA also published an investigation into this one for Sainsbury's. So let's play this one, please.
Eat better feels too hard, try your harvest.
Harvest?
Yes, we'll mix half lentils into half mince. Half chickpeas will meet half chicken, and half beans will meet half beef. A chop here, a change there, and we'll help our health and planet, because today we're eating better, one dish at a time. Sainsbury's, helping everyone eat better.
So helping everyone eat better, also helping the planet. There couldn't really be a more general kind of claim. But the ASA was okay with this one because it wasn't advertising any particular product. It was really promoting a meat-free diet in general, or in this case, the idea they had was that you would halve the amount of meat and put in something like chickpeas or beans to bulk it out. And so because it was about the diet, but not about a particular product, there was no need for the full life cycle analysis, and the ASA were prepared to accept that. So we can go to the next slide. I'm not sure if I've got another. Yeah, so look, that's the explanation. We've dealt with that. There we go.
All right, great. Thanks, Brinsley. One of the hot topics right now is, what about all these corporate commitments that they're going to be carbon neutral by 2040, or they're going to, be entirely powered with renewable energy by a certain point? What kind of proof do you need for claims like that? Daniel?
Sure. So a video. Can you play it, please?
Imagine that we can produce more food without overtaxing the earth, that we revive agricultural land and waste fewer resources. Imagine that no one has to leave their home to flee famine and that there are fewer conflicts. Now imagine that it's a bank working towards this vision. A bank founded by and for farmers, that understands you can achieve more together and knows all about food and how to grow it. Imagine that we help kickstart the smartest innovations by our customers and partners on a global scale and jointly address the biggest food issues on 6 continents. Imagine that we can solve the world food problem together, and you can count on us. Growing a better world together. Rabobank.
Yeah, so that's an aspirational claim from a bank, nonetheless. Yeah, so this case was about the statement. Imagine that we can solve the food problem together, and that you can count on us. And that was a bit strong, and so the Advertising Code Committee in the Netherlands thought that was too strong, and it wasn't really clear that. This was just an aspiration, not just and not like a guarantee that we're going to solve this problem. So it was held to be misleading. Now, generally, in terms of aspirational claims, as an advertiser, you should not suggest that you're already there, that you've accomplished the goal that you're aspiring to reach, or that you're further in reaching that goal than you really are. So that's basically the rule of thumb in the Netherlands. There is, again, proposed legislation. I was already referring to that earlier, amending the Unfair Commercial Practices Directive. So aspirational claims basically should be substantiated by a feasible implementation plan, verifiable targets, backed by sufficient budget, resources. Plans must be publicly available and regularly updated and monitored by an independent body, which is, well, pretty far-reaching. But this also is still a proposal. It's not the law yet, so we'll see what happens. In our self-regulatory code in the Netherlands for sustainability advertising, there is a specific stipulation on this. Aspirational nature must be sufficiently clear. It's an aspiration, not a fact or whatever. And it's misleading to advertise an aspiration that cannot be reasonably expected to ever be achieved. So you have to be realistic in the Netherlands.
Okay, Jonas.
Yes, thanks. So the question was, do aspirational claims require substantiation? And in short, the answer under Swiss law is yes, if they include a statement of fact. And a representation with respect to a future matter may be considered misleading if the advertiser has no reasonable ground for making the representation. And by way of example, if you claim to make a product less carbon emitting, then you should at least have a solid plan for such carbon emission reduction. And you should be able to show that achieving this goal is realistic, not far away. That's
Great.
it. Thanks.
Thanks. All right, Hande.
Well, our guideline also responds to this question. So it says that aspirational claims are acceptable if they are verified with a strategy plan, which is accessible, publicly accessible to the consumers. So I have a decision on the next slide about an airline in Turkey. No, not this one. Yes.
Yeah.
So in this decision about Pegasus Airlines, so the company made the statement that we reduce our carbon emission 20% by 2030. The board accepted this claim and didn't find it misleading because the company was able to provide a publicly open and verifiable plan to substantiate such goal. So yes, they are acceptable if they are supported with concrete facts. Thank you.
And finally, Brinsley. Brinsley, I think you're on mute.
Sorry, thank you. This was a high-profile decision last October, again by a bank, HSBC, about how they were going to transition towards net zero and how they were helping their clients to transition towards net zero. There were two aspects of the problem with this. One was what's sometimes called by critics green spotlighting. So they were spotlighting all the money that they were putting into carbon neutral and net zero kind of investments, but they were ignoring the fact that they were continuing to fund an enormous amount of fossil fuel extraction and environmentally damaging activities. And therefore that kind of cherry picking or green spotlighting was one issue. But as a result of this, the ASA said, look, if you're going to have adverts about net zero or achieving carbon neutrality, they've got to be based on this verifiable and deliverable strategy, much like we're seeing in the other countries. There is an interesting example for those of you who have access to UK TV, or you can probably find it on YouTube. There's a cruise ship company called MSC Cruises, and they've got adverts at the moment which talk about their aspiration to hit net zero. And they then have a link to their website where they have a ton of information about their sustainability plans. This was an example of good practice. This was BP, where the ASA received a lot of complaints from one particular environmental lobby group and their followers. But the ASA said, no, this is okay because you've got those icons down the left-hand side, the first one of which says oil and gas. So BP were not green spotlighting. And then I think on the next slide, I think I've stated the disclaimer, which is in the small print at the bottom of there. Today, most of our production is in oil and gas, but as we transition towards net zero, that will change. This decade, we plan to increase to 50% our capital expenditure on transition business globally and reduce oil and gas production by around 40%. So with that disclaimer and the icons, the ASA was satisfied that they were doing enough. And also they had the signpost to their website where there was more information about the plan that they've got, which was then verifiable by consumers as to how this transition towards net zero was going to be achieved. So that's another example of good practice.
One of the areas where we don't have great guidance in the U.S. is on claims about carbon neutrality and net zero. These are claims that are commonly used by marketers, but at the moment, the FTC hasn't given specific guidance on them. In the U.S., the FTC is currently reviewing its green guides, so we expect that at some point before too long, we're going to start to see some guidance in this area. But right now, we're looking to others around the world to get a sense of what the smartest way is to approach these kinds of issues. So we'll start again with Daniel.
Yeah. So thanks. So in the Netherlands, there has been some very interesting case law from our self-regulatory body about CO2 neutrality claims. I mentioned our a code for environmental advertising, or code for sustainability advertising now, and that contains pretty strict substantiation requirements, especially when an environmental claim or sustainability claim is absolute, and a CO2 neutrality claim is held to be an absolute environmental claim. And so our advertising code committee held in a few cases actually involving Shell's advertising that you cannot base a CO2 neutrality claim based on a carbon credit scheme. So a carbon credit scheme, I mean, with that I mean the arrangements in which you buy carbon credits that stand for a certain amount of CO2 that is absorbed by, for instance, forestation projects. And our advertising code committee holds that carbon credits schemes they're theoretical, and those schemes offer insufficient substantiation for a neutrality claim. So the burden of proof is very, very high, and advertising must irrefutably prove that CO2 neutrality is actually and permanently, not unimportant, achieved. So that's the level in the Netherlands about CO2 neutrality. Yeah.
All right, Jonas.
Thanks. So yeah, my general advice here would be always be transparent and specific. So if you do speak about CO2 emissions or use them in your claim, then you should really make clear to the consumer whether the product is produced without or with reduced CO2 emissions, or that some of the emissions are just compensated during the production. And it is also even always good to refer or use internationally recognized or well-established certifications, such as the one you can see on the slide, the Carbon Trust BAS 2060. Of course, only if you do meet all the requirements for this certification. Thanks.
Okay. All right, Hande.
Well, actually, can you pass to the next slide? This is only a general information. So as I have already mentioned, actually, the advertisement must clearly indicate to which section, part, or process of a product or service. It must be very specific about that. So if a zero emission claim is used, it must be explicitly mentioned whether this claim refers to the before sales or after sales portion of the manufacturing process of the advertising board. And the burden of proof, the substantiation level is quite high here. I have a decision about IKEA on the next slide. So in this decision, the board reviewed the company's claims, how the horizontal packaging helped them to save fuel consumption and carbon emission. So the board reviewed all documents provided by the company together with a calculation sample. So the company also provided a sample to the board to explain how they calculated this environmental impact. And then the board confirmed that the horizontal packaging indeed decreased the number of vehicles needed for carrying the products. And therefore, it helped the company to reduce the fuel consumption and carbon emissions. So I think this decision shows how deeply the board review such claims. So I think that's all for. Okay, sorry. So I mean, there are also quite detailed rules about biodegradability, reclaimed water, renewable energy, which you can see here. For instance, in a decision, the advertiser used the claim manufactured by wind energy, but the board conducted an investigation, and it has been found out that only 50% of energy used in manufacturing process was wind energy. So the board found this act misleading. So these kind of claims, the level of substantiation is higher actually, according to the guideline. Thank you.
Okay, and Brinsley.
Yeah, so this is an interesting area. This is one of these sort of shifting sands areas because it has been traditionally, many of my clients, particularly sort of energy generation clients, advertising green energy tariffs have relied on offsetting type schemes, but they do now seem to be increasingly under the spotlight and being challenged. People saying that basically they're not as effective as has previously been claimed, and therefore that is it's an area of increasing scrutiny at the moment. Also, I think you've got to be clear as to the extent to which you're actively reducing your carbon emissions as opposed to relying on offsetting. And any information that you give has got to be juxtaposed with the claim so that the consumer will be able to see it and take account of it before making any kind of decision. I've already touched on the point about verifiable delivery strategies for net zero claims in general. So, yeah, I mean, I'm expecting this to be an increasingly contentious issue, and advertisers that are relying on offset schemes to substantiate their carbon neutral claims, I think, are going to be subject to increasing amounts of scrutiny from now on.
So one of the hottest issues right now in the US is what does it mean when you claim a product is recyclable? There are very well-established standards about what that means, but there's a new law in California which is changing the standard, and the FTC is asking pretty hard questions about whether it should change its guidance in that area as well. In fact, the FTC is holding a workshop on the meaning of recyclability claims in about 2 weeks in DC. So let's see what's going on this front. Let's start with Daniel.
Yeah, so our rules are from our self-regulatory system. So you can only claim that a product is recyclable if recycling is actually sufficiently achieved or possible with the advertised products or components. And more of a general rule, it should be clear which part of the product or the whole product the recyclability claim concerns.
I'm sorry, Daniel. Is possible enough, or does it have to be achieved? Notice, do you have to show that the product?
It is the possibility under our self-regulatory rules in the Code for Sustainability Advertising, the realistic possibility that it can be achieved, so that for instance the recycling installations and technique is there, would be sufficient.
Got it. Okay.
Yeah.
All right, Jonas.
Yes, so this touches on what just Daniel really said. So also over here, you should prove that all the parts of the product are recyclable, or if not, then specify which ones are. And the consumer should also be able to actually have them recycled. But there, I would say we take a bit more liberal approach, and you can also work with asterisks and explaining if there's some, or making a disclaimer if a certain element is not recyclable. And on the upper part of the slide, you see an example which was subject to a complaint by a consumer brought before the self-regulatory body. And the complaint was basically that the batch over in the left-hand corner on the top, 100%, and the suggests that the whole product, or I mean the paper, toilet paper, is recyclable or recycled paper, but in fact it was only the packaging. And the complaint was dismissed because it was, according to the self-regulatory body, it was easily readable for the average Swiss consumer, and also understandable that it was really referring to only to the packaging and not to the whole product. and it was also considered that it was separated from the rest of the product. And on the lower part, you just see another example where one can see that they use disclaimers and still make a claim that the packaging is recyclable. And then further down in the disclaimer, it's not readable, but it says that it is subject to availability in the end. And I would say that is still fine. And one point to consider is that unfair competition is not only where there is actual deception, but the risk of deception would be considered sufficient under Swiss law. So yeah, that's it.
Okay, Hande.
Well, I will be very brief about it because, it's very similar to Switzerland. So if you put this recyclable sign on a bottle of product, but if the bottle cap is not recyclable, then this is misleading. So you have to put the disclaimers if the recyclability claim doesn't cover the whole packaging of a product. So very much similar, actually. And that's all for Turkey.
Okay, Brinsley.
Yes, I suppose, similarly, so you've got to say whether, you have to provide substantiation whether you're either saying that the product is made from recycled material or that it can be recycled. And I think to the point that you were asking, Jeff, there is always a concern as to whether or not a recycled product can be recycled in your ordinary kind of curbside collection by the local authority, or would you have to take it somewhere specific for it to be recycled, in which case you're probably going to have some very clear disclaimers. As ever, you have to be able to produce this substantiation when you go to press. And don't exaggerate what is the level of recyclability or the recycled content. So you can see in this case, Pepsi have a brand, Lipton Iced Tea, great big claim in that advert, 100% recycled. You can barely see that after the word recycled, there's an asterisk. And you certainly can't read that below the lemon, there's a disclaimer, which I think might be on the next slide, which said, bottle made from recycled plastic excludes cap and label. And the ASA said, well, hang on, 100% recycled would imply to the average consumer that you mean everything is made from recycled components. The disclaimer is just too small. People are going to overlook it and not see it. And in any event, even if people see it, it contradicts the headline claim. It doesn't clarify or explain it. You've got an absolute claim in the headline, which is then contradicted in the disclaimer. And that's just a basic, fundamental no-no of all advertising regulation. So that ad was banned following only one complaint, which is another feature of our self-regulatory system. One well-founded complaint is enough to trigger an investigation and can lead to an ad being banned.
Interestingly, the FTC's guidance says the opposite here, or says basically the opposite here, which says that you can claim a bottle is made of recycled content even if the cap is not recyclable because it's an incidental component. We'll see if they change that guidance in the new review. But I think the issue actually is a little bit different. That the FTC's green guides have always been focused on this idea of the availability of a recycling process, meaning curbside recycling programs. And in fact, you're not supposed to make a general recyclable claim unless recycling facilities like curbside recycling are available to, I think it's substantial majority, I think that's the word, of communities, which is like 60%. But the question that's on the table right now is, can you make a recyclable claim, even if it's generally available or a substantial majority is available for curbside recycling, if the actual recycling rates of the recycling facilities are also not at very high levels, meaning if you can get your stuff to a recycling facility, but they just are getting too much stuff and they only have capacity to actually recycle a smaller percentage of that. Are advertisers responsible for following through and making sure that it will in fact be recycled? Is anyone seeing that anywhere?
We're seeing that concern, definitely. people are increasingly alive to that issue and to the fact that we also are exporting our waste to other countries and turning it into their problem. I haven't yet seen it sort of form the basis of complaints to the ASA, but I think it's entirely possible that it will. It's an interesting possibility.
All right. Second to last topic: seals and certifications. Daniel.
Yeah. So starting to sound like a broken record, but there are no specific statutory rules, not yet, in the Netherlands. But there is an EC proposal, which I've already mentioned. And there is a ban in there on displaying a sustainability label that's not based on a certification that are not established by public authorities. Our code for sustainability advertising does have a specific rule on labels, seals, certification. Well, they may be used provided that the origin is clear and confusion as to the meaning of the designation or symbol is ruled out, which I think is very reasonable and just is something to prevent misleading the consumer, really.
All right, Jonas?
Yes, thanks. So yeah, I would say we should always bear in mind that seals and certifications, they always kind of simplify a statement. And therefore, of course, they entail an increased risk of deception. And in order not to produce such risk, you can, as I mentioned before, you can surely use disclaimers or even direct the consumer online for further information. And it is also worth noting that some eco-labels, such as IP Swiss on the right-hand side of the slide, are protected as either guarantee marks or collective marks, and guarantee marks being trademarks that guarantee a certain characteristics of goods and or services. And the IP Swiss, it stands for integrated farming or integrated production. So if you meet these requirements, then of course you are able to use this trademark. And collective marks being trademarks that really are trademarks for goods and services of an association, as by way of an example, VvRr, if you are aware of them, they are such a trademark, and if you do comply with the trademark owner's policy, then you are also able to use such trademarks. Thanks.
Hande.
This is also, I mean, the seals and certifications are also regulated under the guideline, and only the seals and certifications of accredited testing institutions or the ones approved by national institutions can be used. And also the consumer must be informed about the seal and certification, and this information must be communicated to the consumer in a medium where they can easily access to the information to what that seal or certification represents. So the consumer must be fully aware of that. The guideline gives an example about the use of seals and certifications. A beverage product had a seal on it stating that the Environmental Friendly Packaging Association. So they just use the seal of such an association. The board investigated this claim, and they found out that yes, there is such an institution, there is such an association, but they don't conduct any research or examination about the environmental impacts. So the use of such a seal was found misleading by the board. That's all for us.
Okay, and Brinsley.
Yes, so there was some guidance from the Competition and Markets Authority, so from the legal body, rather than the self-regulatory organisation, the ASA, saying that all these labels and symbols have got to meet the necessary standards and be authorised. If they come from an independent third party, they're less likely to be misleading than the ones that kind of companies make up for themselves on their own packaging and branding. And also this encouragement to use verification to sort of for example, give people a flag, a pointer to your website where they can find more information that allows them to verify the certification that's being advertised. Those are the key principles in this area. Sorry, and there was then just a couple of worked examples. The corn example, complaints about this advert for corn, which is a meat substitute product, directed people to the Carbon Trust certification, and the ASA were concerned that people would think that by buying a pot of corn, they would immediately reduce their carbon footprint. And it didn't make sufficiently clear that actually this was a commitment to reducing carbon footprint over a period of time. Again, I'm concerned that this is the ASA assuming that consumers are very naive and would imagine that simply by buying one pot of a product, that's going to have a massive impact on its own. I'm not sure consumers are quite that biddable. But anyway, the complaint was upheld.
Thanks, Brinsley. Okay, so before we wrap up, a quick word from each person about what's next in your jurisdiction. What do you think is going to happen?
That's a lot. I'm going to be quick here. So I've touched on all these subjects, I think, in the past few minutes, and so it's coming. The EU proposal for that EU directive amending the Unfair Commercial Practices Directive. And next slide, please. There's also a proposal for the Green Claims Directive, and these are important developments following the European Green Deal, and they're going to have an impact, but they're not going to have an impact very soon because, well, this, for instance, this EC proposal for the Green Claims Directive, it still has to be approved and possible amendments by the European Parliament. So that can take around 18 months or something like that. And once it is adopted, member states will have to implement it, transpose it into their national legal systems. That could take, well, another, they would be required to implement it within 18 months following the adoption by the Council and European Parliament. And then to apply it actually is 24 months. So it's still in the future, but it's heading our way, and we should definitely take note. Thanks.
Something to look forward to in like 7 years. All right. All right, Jonas.
Yes, thank you. So we do expect some further case law and also guidance on the environmental marketing. And for example, on the case law in a self-regulatory context, some of you might be aware of the complaint which was brought forward by the Climate Alliance Switzerland against FIFA in connection with the World Cup in Qatar 2022. It relates to a statement made by FIFA on their website that the whole tournament will be completely carbon neutral. So this had been challenged, and the decision is still to come. And also, I wanted to draw your attention on a broader context on the very hot debate on claims for vegetable substitutes for meat. We have a pretty interesting case pending at the Swiss Federal Supreme Court. It relates to Planted. Planted is a very successful Swiss producer of plant-based food. And the question there is whether they are allowed to use claims such as planted chicken, planted bull barbecue, or like chicken for their products, and whether or not they are deceptive. So the Zurich Administrative Court considered them not to be deceptive. And this has in fact been challenged by the Swiss Federal Department of Home Affairs, and we expect a decision in this respect later in the year. And on the right-hand side, you can see just an example of the packaging, which is part of this debate.
Yeah, this is a big debate in the U.S., particularly in the meat-producing states. We're seeing some state laws on this issue. Okay, Hande.
Well, actually, we expect strict scrutiny by the advertising board because, actually we have the rules, the statutory rules about the environmental claims since 2003. But to be honest, the environmental claims has never been a hot topic for the advertising board until recently. So with the enactment of the guideline, now we expect that there will be more decisions from the board, and the guideline will help to establish a uniform practice in Turkey. So we will be discussing these environmental claims a lot in the next year, I guess. Yes.
And Brinsley, what should we be expecting from His Majesty's government?
Well, His Majesty, of course, has always been an environmentalist. He was leading the way in environmental concerns since his early days as Prince of Wales. We've had now this guidance from the ASA about net zero and carbon neutral claims. So I think what we're going to move into now is them looking around, probably initiating their own investigations where they can into claims for net zero and carbon neutral and those kinds of aspirational claims. The Competition and Markets, meanwhile, has announced its intention to help the UK's transition to net zero, and will, I think, also be looking to see whether they need to stop greenwashing in that area. We're waiting with bated breath to see what the EU does on green claims, and whether we will follow suit with maybe some legislation of our own. I suspect that by the time the EU directive comes into force, we'll have a different government. We're probably going to have a general election next year. The current Conservative government is highly likely to lose power, and a Labour or Lib Dem or coalition kind of government is probably going to be more sympathetic to having something equivalent to a green claims directive. And the other thing we might see is the addition. The consumer protection regulations have a list of 31 banned practices, which are always unfair, if you like, strict liability offences. And it is possible that unsubstantiated green claims could be added to that list, which would be quite a good way of dealing with this issue. And then it would become a matter of criminal law to make an unsubstantiated green claim. That could happen, again, probably more likely if we have a change of government. And then we also might see some standardized definitions of various terms relevant for green claims in marketing and particularly in labeling coming from the CMA. So those are all possibilities that are on their way in the reasonably near future.
All right, Brinsley, Daniel, Hande, Jonas, thank you. And to all of you who joined us, thanks so much for joining us for our first green marketing webinar of the year. Look out for the second one coming in the next couple of months, where we're going to talk about green marketing in the Americas. And if you want more information about these types of issues, as well as sort of the other IA initiatives, you should visit the IA's website at ia.global. We've got a whole section of their public policy issues, videos, webinars, all kinds of interesting things to check out. Everyone, have a good day. Take care. Thanks all.
Bye.
Thank you.